Welcome back. You're watching Front Row, and tonight we are discussing the Children Bill of 2021, which seeks to repeal the Children Act of 2001 in a bid to seal a number of legal loopholes as much as the rights and welfare of children of Kenya are concerned. And we want to continue with this discussion. Of course, I'm in studio with child welfare advocates and experts. And I want now to engage Charles, who is joining us from Kisumu. And Charles, the cities of Nairobi, Kisumu, and Mombasa, I understand, are where trafficking of children occurs the most. And traffickers traffic children for domestic servitude, sexual exploitation, as well as forced labor. Of course, issues that have time and again come and been highlighted in the media, issues that you also deal with. What is a judicious plan to put an end to child trafficking in Kenya, and how does this bill address this?
Thank you so much for the question. And also the towns that you've highlighted are really, hotspots for such violations of children. And it's simply because they are what you may want to call transit points or access points to promote, cases of child trafficking. So there's a demand for such kind of illicit services, as you mentioned. And I'm glad you mentioned, child labor, sexual exploitation, and, child marriage and the like. So when you look at the bill, it has definitely given a lot of power to the cabinet secretary to pronounce himself on cases of child labor. So, for example, he's supposed to come up with guidelines on the kind of work that a child should do, especially a child between the ages of 13 to 16, and definitely a lot of stiff penalties for cases of sexual exploitation. When it comes to the challenges in the judicial system, we have quite a number. And one of them is the fact that we have a law, first of all, so that's something that is commendable to the government. We have the Trafficking in Persons Act of 2010. But the challenges we have in the judicial system is we do not have sufficient shelters for victims of child trafficking. So we get such victims really suffering in the process. And when it comes to training, from the judicial officers, that is the magistrates, the police, prosecutors, chiefs, people do not have a good understanding or appreciation of the Trafficking in Persons Act of 2010. And this is reflected when you look at the charge sheets, how they're drafted and they're taken to court. You find that they're not drafted in a proper way. So we need a lot of investment when it comes to training. When you look at the training centers where police officers are trained on their basic knowledge on human rights and the rest, child trafficking is not one of the topics that's covered in the training centers. So these are trainings that are offered on an ad hoc basis from different partners in the sector. So this is an investment that really needs to be put in place so that the necessary judicial officers get sufficient training of the same. When victims come to police stations, the way they are treated, the way they are talked upon, they're not given sufficient psychosocial support to help them really recover well or even go through the whole criminal trial process as should be. When you go to the county level, the Department of Children's Services has put in place necessary mechanisms to take care of cases of child trafficking. So, for example, at the county level, we have the County Coordinator for Children Affairs, who takes care of such kind of cases when they come up. And when you go to the sub-county level, we have the Sub-County Children Affairs Officer, and we have different child protection volunteers who respond to such cases. So the main call, especially in the bill, and also as child rights activists or advocates, is we are calling for a lot of investment to be put in terms of creation of knowledge, sensitizing people on the different offenses and the different penalties associated with child trafficking.
Right, Charles. And even as we speak about, legal redress and framework to address child trafficking, one would be wondering the context in which it happens when we think about preventing them in the first place. What would you say are some of the instances that it happens? And who tend to be the perpetrators, even as we speak about preventing this kind of cases?
Perpetrators are basically me and you, Sharon. These are basically people who are sourcing for cheap labor from upcountry, and that's why those towns are really, the key towns, as you mentioned, Nairobi, Mombasa, and Kisumu. So they're sourcing for cheap labor, for example, house managers who are in houses, and definitely ensuring that they get the services from, their different partners in the community.
Right.
And sorry.
No, I was just responding to acknowledging your point.
Oh, okay. So, and we have a lot of unsuspecting children, who are taken to different hotels in the coastal regions, and they're exploited sexually. So we have different campaigns that have come up to try and sensitize hotel owners, sensitize different people in the different business sectors about the importance of protecting children from these different forms of violence.
Okay. Right, that makes sense. Let me bring in Ibrahim now. And the bill addresses allocation of resources to child welfare programs. What programs are these, for instance? And what is the deficit from where we are now to what we want to achieve?
Thank you, Sharon. So we begin by acknowledging the fact that if you look at the current Children Act, it doesn't expressly provide, or rather it doesn't expressly guarantee the right to social security. So what the bill does first and foremost is to assert that right under clause 11 of the bill by saying that children will be entitled to the right to social security. And it doesn't just start with the bill, it starts with the Constitution. If you look at Article 43, sub-Article 3 of the Constitution, it's very clear that the state is supposed to, come up with what we call social security or social assistance programs to support the vulnerable and people who cannot afford to actually realize, particularly socioeconomic rights. Now, you need to understand that the right to social security within the Kenyan system is actually anchored under Article 43, which basically makes provision for what we call socioeconomic rights, the right to health, the right to food, the right to water, the right to housing, and so forth and so on. So these are a bundle of rights that we call socioeconomic rights. Now, if a citizen is unable to actually attain these rights, the state is under an obligation to ensure that they do that through provision of social security and social assistance. At the moment, we have social assistance programs. We have what we call the Orphans and Vulnerable Children cash transfer program, for example, which supports children largely from who are orphans and vulnerable. Now, one challenge that we've had is the targeting has always been a challenge because whereas these social assistance programs target these children, but we know that most of the populace in this country can actually not realize these socioeconomic rights properly. So targeting has always been a challenge. We are moving towards what we call universal cash benefits or universal children's benefits, so that all children, regardless of their social status, can actually be put at a place where they can, realize this. And UCB is actually one way in which we hope socioeconomic rights will be realized. And at the moment, the World Bank, UNICEF, and many other civil society organizations are actually working towards putting together a pilot program that would ensure that we have universal targeting for children, so that everybody is put at a pedestal where they can actually realize this. Now, getting back to the bill itself, Clause 11 envisages the establishment of what we call a child welfare fund, which will be a fund supported by the national government that would ensure that all children actually attain this right. So, Clause 11 talks about the Child Welfare Fund being established under the Public Finance Management Act to ensure that the government actually puts its money into that fund and it's able to address the needs of children who are unable to attain their socioeconomic rights. We also hope that the cash benefit, the universal cash benefit program that I talked about would also be rolled out so that we can have a situation where children across the board are actually accessing this. And then we're also hoping that the Social Assistance Act, which was enacted way back in the year 2013, but has never been meaningfully operationalized, in the sense that whereas the Parliament actually enacted this legislation, we have not seen the government putting in place structures to operationalize it. A good example is the Social Assistance Authority that was envisaged to be established under the Social Assistance Act. That authority has never been established, and many years down the line, close to 9 years down the line, we have seen that not happening. So we are hoping that with the establishment of the Child Welfare Fund, as envisaged by Clause 11 of the bill, the government would be able to allocate resources, proper resources, so that the economic and social, economic and social cultural rights of children, particularly the right to health, the right to education, the right to water, food, and so forth and so on, housing, can actually be realized within that framework.
Right, right. Okay, let me bring in Pauline now. And Pauline, there are instances where children may not thrive within their biological family setup, perhaps because of abusive parents or many other instances. What then are the proposals for this kind of issue?
Thank you, Sharon. And just to pick up from what my colleague Ibrahim has mentioned, is that the same Clause 11 in the Children's Bill recognizes and actually provides for a new provision on alternative care services, and that this generally speaks to those children who are not able to be taken care of within their biological setup. So it makes provision for services such as adoption, guardianship, foster care arrangements, support for youth in independent living, and then as a last resort, we have the institutions. So the provisions here is to ensure that there are different alternative care options where children can actually thrive. In the case where there's some form of abuse, and they also need to seek redress in terms of protection. So what the bill has done is that by recognizing this, further through the functions of the courts, and maybe through the directions that will be given by the Chief Justice, there are different rules and regulations that are going to be developed on how to handle all these kinds of alternative care. But currently the bill has made provisions for institutions. It's also made provisions for foster care placement of children, guardianship and adoption. But it also recognizes, and Kenya has gone further ahead to ensure the development of what we call the alternative care guidelines for children in Kenya, which basically recognizes all these forms of care. So where, for example, a child is facing some kind of distress within the family, they can get redress based on those different forms of care. And then, of course, as a first resort, we have what you call the child helpline, 116, which is a toll-free number. And this number, anyone within the borders of Kenya can actually call and report that a child is being abused within the family or within the community setup, and specific services will be given to this child before they are removed from their family so that they get protection services. And then, of course, what Ibrahim was mentioning, that the bill also recognizes that families need to be supported, and they will be supported because of the provision of these social protection resources and funds that we are talking about. Right. So that is what the bill says, where children cannot be able to be taken care of within their biological families.
Right. Right. And Charles, let's talk about care of children during emergencies. We've seen cases where children actually end up being separated from their parents and caregivers permanently. Is this a concern?
Yes, it's a big concern. It's an accountability issue. And as child rights advocates, we always promote the whole issue of reunification of children. The first point of contact is ensuring that the children are reunified with their families, because that's the place where they will be mentally stable and they are able to heal. And we must also ensure during emergencies that children have a very good environment whereby they are able to basically feel like they're safe and secure, because that will also promote to their mental well-being. And also in emergencies, we also try and ensure that children are free from trauma. That means even the psychosocial support that they should be given has to be administered by people who are really qualified, people you may want to call specialized caregivers, so that the child basically heals in a holistic way. So basically some mechanisms have to be put in place to ensure that the child gets holistic redress when it comes to recovery. And this will only be done through holistic needs assessment, whereby we're able to identify what are the needs that the child needs, and we ensure that we do response towards that. And as we are doing all this, we are definitely being guided by the do no harm principle, whereby we are trying to ensure that children are not put in a place whereby they are worse off than where they were originally. Now, Section 20 of the Children Bill promotes or offers protection to children from different emotional needs, and also offers protection from different mental needs. So the bill also recognizes that when it comes to abuse or when it comes to protection, it goes further than the physical protection that we are used to, but it also looks at the emotional aspect, looks at the mental aspect, but it also recognizes that nowadays, since we are living in the form of the digital space,
right,
that children are likely to get exploited through different social media means. So the bill under Section 20 kind of like elaborates on that element.
Okay, and we have just about 2 minutes to wind up the discussion. So I'll just start with you, Charles, as we give our closing remarks in just under 30 seconds to list what you say would be priority areas, a priority point or area as your closing remarks as we hope to have this bill enacted.
I think for me, the takeaway here is Section 8 of the bill. It kind of like expounds on the different grounds of discrimination.
Yeah.
I think we're used to, the traditional elements of discrimination, but we are lucky now we have a bill that recognizes this, and also a bill that kind of like breathes life into the Constitution. So I want to just reiterate what my colleague Ibrahim said. We just want to give a thumbs up to the members of Parliament, especially the Business Committee, and different actors who are working on child rights in the push towards the enactment of the Children Bill.
Fantastic. Thank you very much. And Ibrahim, maybe we can get your closing remarks as a takeaway and priority area way forward.
Yes, thank you very much, Sharon, for having us. My big takeaway, again, this goes back to our parliamentarians. This bill is if you ask me how soon the bill should have been enacted, I would say yesterday or probably last year, because children continue growing every day. It's unacceptable for them to continue waiting for a new legal framework to protect their rights more than 20 years down the line. And so I would urge our parliamentarians to actually take a keen interest in ensuring that this bill is passed. And the second takeaway would be to the county governments. One of the issues that the bill has really done is to spell out the role of county governments under Clause 62.
Yes.
County governments are actually expected to come up with policies, legislations, and plans of action to support the promotion and protection of child rights.
Right.
So we also urge county governments to actually do that and also make requisite budgetary allocations to ensure that we actually operationalize all these issues.
Fantastic. Thank you. Thank you, Ibrahim. Pauline?
For me, thank you very much, Sharon and my colleagues. The time is now to enact the bill into a law. The children of Kenya have spoken and they cannot wait any further. We need to use this as an opportunity to address all the concerns on abuse and protection of children. So let's do this now. And a big word to the members of parliament who are also working round the clock to ensure that this bill is enacted into law. So looking forward to seeing that the children will get a new law specifically before we get into elections.
Fantastic. Fantastic.
Thank you.
Thank you very much. Pauline Kedogo is the Advocacy Manager, SOS Children Villages in Kenya. Thank you very much for your insights. Charles Nyukuri was joining us all the way from Kisumu, is the Influencing and Advocacy Advisor at Plan International here in Kenya. And Ibrahim Alubala, Head of Advocacy and Child Rights Governance at Save the Children. Thank you very much, gentlemen and lady, for your insights and discussion. A very awesome discussion. It has been informative and also pushing the advocacy for the child rights of children here in Kenya. Thank you very much. My name is Sharon Momanyi. That's where we wind up the discussion on Front Row tonight. I'll see you again next time. Have a good night.